Hi, everyone. This is Pennsylvania attorney Evan Gutman presenting video number 17 in my legal video education series. The videos are addressing the good moral character standard for obtaining a law license, and the videos are based upon my book titled State Bar Admissions and the Bootlegger's Son. The full content of my book is available on both of my websites. I have two of them. One is titled heavensadmissions.com, and the other website is gutmanvaluations.com. Both websites, in addition to containing the full content of State Bar Admissions and the Bootlegger's Son, also contain a supplement that I wrote to that book, as well as a fictional novel that I wrote titled Heaven's Admissions Process, which is a somewhat humorous, comical, and enjoyable novel, hopefully, that addresses the criteria for being admitted into heaven and compares it with the criteria for utilizing the good moral character standard to obtain a law license on earth. All of my videos have a PDF associated with them, which comes predominantly from my books. And you should be able to obtain the PDF on the website that you're looking at this video on currently. Certainly it should be on Facebook. Hopefully it will be on YouTube. Still working on that a little bit. Video 17 addresses U.S. Supreme Court cases that dealt with the good moral character standard related to the bar admissions process. And they're quite interesting. One of the most interesting things about the U.S. Supreme Court cases is that the state Supreme Courts quite often do not comply with the U.S. Supreme Court cases. And the U.S. Supreme Court has had a lot of difficulty with this issue. As a result, they really have never come down with a totally decisive opinion, although clearly there are aspects of the opinions they have issued that are not being complied with by state Supreme Courts. So we're going to address a number of cases here. The first case goes back to 1866, and it's a key bar admissions case. At the U.S. Supreme Court, the title of the case is Ex parte Garland. And what occurred was that the case is being addressed in 1866, right after the Civil War. The Civil War had ended, and a man named A.H. Garland, who was previously admitted to practice law before the U.S. Supreme Court prior to the Civil War, he followed his home state of Arkansas when it seceded from the Union. And he actually also became a member of the Senate for the Confederacy. So then the war ends, the South lost the war, and the seceded states become part of the Union again, and he wants to get his law license back. The problem is that the U.S. Congress had passed a legislative act that prohibited any person from being a member of the bar of the U.S. Supreme Court unless they subscribed to a loyalty oath. And Garland refused to subscribe to the loyalty oath. He challenged the constitutionality of the Congressional Act before the U.S. Supreme Court. The main opinion in the case, the lead opinion, is written by U.S. Supreme Court Justice Stephen Field. And Justice Field is actually a remarkable individual himself. In one of the later videos of this series, I'll be talking more about his background. Just quite quickly, I will tell you that Justice Field himself, prior to becoming a U.S. Supreme Court justice, he was held in contempt of court twice, not once. He was held in contempt of court twice before becoming a U.S. Supreme Court justice. So he rules in favor, the court rules in favor, utilizing his opinion, his lead opinion. The court rules in favor of Garland and declares that the Congressional Act prohibiting becoming a member of the bar unless one subscribes to a loyalty oath is unconstitutional. And the U.S. Supreme Court writes as follows: the attorney and counselor clothed with his office, does not hold it as a matter of grace and favor. The right, the term it uses, the right, which it confers upon him to appear for suitors and to argue causes, is something more than a mere indulgence, revocable at the pleasure of the court or at the command of the legislature. It is a right of which he can only be deprived by the judgment of the court for moral or professional delinquency. Then it says this: the legislature, it says, may undoubtedly prescribe qualifications for the office to which he must conform. The question is not as to the power of Congress to prescribe qualifications, but whether that power has been exercised as a means for the infliction of punishment against the prohibition of the Constitution. Now, the two key things in this case, the two real key things in this case, are one is that the U.S. Supreme Court is expressly stating that a law license is a right rather than a privilege. And I discussed this in an earlier video that addressed the concept of right versus privilege. The other aspect of this opinion that's particularly interesting is that the court is recognizing the right of the legislature to prescribe qualifications for the practice of law rather than just the judiciary. And in the video that I previously presented on the history of the attorney licensing process, I pointed out that many state Supreme Courts today assert quite falsely that only the judiciary can prescribe qualifications in order to become an attorney and that the legislatures can't. But in fact, until 1931 or so, the early 1930s, many states had held that the determination of the standards to be applied for obtaining a law license could be prescribed by the legislatures. The next case I'm going to address is a case called In Re Summers. This is a 1945 case, and the petitioner Summers was denied admission to the Illinois bar on the grounds that he was a conscientious objector who opposed the use of force for religious reasons. He refused to advocate force and subscribed to the concept of passive resistance. As a result, he refused to take a loyalty oath to the Illinois bar because that oath would require him to essentially abandon his conscientious objection to military service. The U.S. Supreme Court describes the position of Petitioner Summers. Petitioner Summers' position as described by the U.S. Supreme Court, or as pointed out that he described it to the U.S. Supreme Court, is as follows. Quote, the so-called misconduct for which petitioner could be reproached for is his taking the New Testament too seriously. Instead of merely reading or preaching the Sermon on the Mount, he tries to practice it. The only fault of the petitioner consists in his attempt to act as a good Christian in accordance with his interpretation of the Bible. The interesting aspect of this case is, first of all, the Illinois bar did not deny that the petitioner was honest, moral, intelligent, had never been convicted or charged with the violation of any law. And yet they denied him admission because he refused to take the loyalty oath. The loyalty oath cases are somewhat predominant in the bar admission cases, at least up until the late 1950s or so. The U.S. Supreme Court rules against Summers. The U.S. Supreme Court asserts that the petitioner Summers' inability to take the oath to support the Constitution of Illinois, which required a willingness to serve in the armed forces, was sufficient grounds for denying admission. The next case that we're going to talk about here is a 1957 case that was at the U.S. Supreme Court, which is titled Schwarre versus Board of Bar Examiners. This is a landmark bar admission case. The applicant was denied admission to the New Mexico bar. He had several arrests related to participating in labor protests, and it was believed that he was a communist. Essentially what happened here was that he filed a complete and truthful application. No doubt about that. As a point of fact, the application itself did not even inquire as to whether he was a member of the Communist Party. The application didn't even inquire. In what make the inquiry? Ask the question. But the bar received confidential information that he had once been a member, and based upon this confidential information, they held a bar hearing. At the bar hearing, the bar refused to let Schwarre see the confidential information that they obtained. Furthermore, even though they used the confidential information for purposes of denying his application, they did not make it part of the record of the hearing. So there was a lot going on here. The U.S. Supreme Court, in an opinion written by Justice Hugo Black, rules in favor of Schwarre. The most important part of the opinion, in my view, is the U.S. Supreme Court recognizing that he had several arrests but no criminal convictions. The U.S. Supreme Court writes key sentence, one of the most important sentences ever, which is that the mere fact that a man has been arrested has very little, if any, probative value in showing that he is engaged in any misconduct. In other words, if you're not convicted and you just got an arrest, it doesn't mean that much. The interesting part about this, though, is that case came down in 1957, and it's still good law today. And notwithstanding the fact that the U.S. Supreme Court says an arrest has little, if any, probative value, the fact of the matter is the state Supreme Courts and the state judiciaries and the state bars essentially ignore that statement. They do not follow it. Instead, what they do is every single bar application in this nation, so far as I know, does in fact include a question: have you been arrested? And if so, disclose all information related to the arrest. Now, if the U.S. Supreme Court is saying that an arrest has very little, if any, probative value, then there shouldn't be a question about it. So in my view, the state bars, state Supreme Courts are, for decades, have been violating that express statement in the Schwarre case. Now, the next case in this section of this video, the next case is actually two cases. And the reason I say it's two cases is because it's the same bar applicant, but his case goes to the U.S. Supreme Court twice. The first time it goes to the U.S. Supreme Court is in 1957. The case is titled Koenigsberg versus State Bar of California. The U.S. Supreme Court rules in his favor, but on narrow grounds. As a result, the case gets remanded back to the State Bar of California. Now, what happened in this case was that the applicant Koenigsberg, he refused to answer questions that the bar posed about his political affiliations and beliefs. He is denied admission by the California bar. However, the California bar does not deny him admission based on his refusal to answer the questions. They simply determine that he does not have good moral character. So the U.S. Supreme Court is faced with two issues. First is, does refusal to answer a question in and of itself constitute grounds for denial of admission? Second is whether the California bar had grounds to deny him admission based upon the record with respect to their conclusion that he lacked good moral character. But the California bar does not deny him admission based on his refusal to answer the question. So the U.S. Supreme Court sidesteps that issue. They sidestep the issue as to whether he had a right to refuse to answer the questions pertaining to his political affiliations and beliefs. Instead, the U.S. Supreme Court simply notes that there's not sufficient information in the record to indicate that he lacks good moral character because the California bar did not rely upon his refusal to answer the questions, and they remanded it back to the California bar. So it goes back to the California bar. And what happens this time is the California bar does assert that his refusal to answer the questions constitutes grounds to deny admission. So now the case goes right back up to the U.S. Supreme Court, and the opinion is issued 4 years later in 1961. And the U.S. Supreme Court, in an opinion written by Justice Harlan, asserts that his refusal to answer questions is grounds for denial of admission. Justice Hugo Black, who had written the lead opinion previously, ruling in favor of Konigsberg, writes a stinging dissent. Stinging dissent. What he basically says here, which is totally correct in my view, Justice Black, in his stinging dissent, he writes as follows. What the committee did, and he's referring to the California Bar Committee, what the committee did upon remand was to repeat the identical questions with regard to Konigsberg's suspected association with communists 20 years ago that it had asked and he had refused to answer at the first series of hearings. Konigsberg again refused to answer these questions, and the committee again refused to certify him. This alone would be enough for me to vote to reverse the judgment. Previously, prior to that paragraph, Justice Black had written as follows. When this case was here before, we reversed the judgment of the California Supreme Court, barring the petitioner Konigsberg from the practice of law in that state. In doing so, we held there was no evidence in the record which could rationally justify such a conclusion. So the U.S. Supreme Court basically ruled in Konigsberg's favor in 1957, then ruled against him in 1961. And Justice Hugo Black wrote the lead opinion in 1957 and wrote a dissent in 1961. Justice Harlan was basically the individual who wrote the lead opinion in 1961. So we're going to talk more about some additional cases in the next video. I hope you enjoyed this, found it interesting. The U.S. Supreme Court has had a lot of difficulty with the bar admission cases, and they're very controversial. Virtually all of them are decided on as 5-4 opinions. So I hope you found this enjoyable, and we'll have the next video on in the next day or 2 or 3 or 4. And remember, love right, don't fight. Bye.